Good day, Mom. We are from Group 4 and we are here to report about the non-institutional corrections programs. So first, the probation. Probation is a procedure wherein a sentence of offender is temporarily suspended and he is permitted to remain in the community, subject to the control of the court and under the supervision and guidance of a probation officer. It is a privilege granted by the court to a person convicted of a crime or criminal offense to remain with the community instead of actually going to prison. So, in other words, probation is considered as procedure, as a second chance given to a convicted offender wherein his sentence will be temporarily suspended and he has a chance to serve his sentence in the community. Bisan naa siya sa community, under supervision and guidance sa probation officer gihapon siya. The probation officer will be the one to monitor and supervise all the things nga gipangbuhat sa probationer. It is a privilege because the court, meaning ang court mismo nga nagunit sa kaso, dito gihapon himuon ang petition or dito himuon or buhaton ang pag-grant sa probation before siya matawag nga probationer. Instead nga mag-serve siya sa iyang sentence sud sa kulungan, he has now the chance to remain in the community. So, it is one of the helpful program of the government to ease the overcrowding in jail and also to restore the dignity of the offender. So next, the probation law proper. The basic element of probation. The first, a suspension of sentence. Second, a period of trial for offender in the community. Third, the offender's observance of the law and adherence to the condition imposed by the court. And fourth, the supervision of the offenders by a probation officer. Next, the essential elements of probation. First, a post-sentence investigation report which will serve as informational basis of the court's decision to grant or deny probation. So we have the PSIR or the post-sentence investigation report na basihan kung i-grant or dili ang probation ngadto sa nag-apply sa probation. Second, conditional suspension of execution of sentence by the court. So, pwede masuspend ang sentence sa offender. Third, conditions of probation imposed by the court to protect the public safety and to transfer the rehabilitation and reformation of the probationer. So, naay condition wherein kailangan sundon or tumanon sa offender. Ang purpose sa condition nga ihatag is to protect the public safety and also to foster the rehabilitation and reformation. So, fourth, supervision, guidance, and assistance of the offender by the probation officer. So, we will move on to the petition for probations. Petition for probations, kung unsaon ang application or unsaon pag-petition. So, submission of probation. A petition for probation may be filed by a petitioner directly to the court who exercises jurisdiction over his case. So, meaning, ang petitioner mismo or nag-apply sa probation ay pwede direktar nga mo apply ngadto sa court wherein ang kadtong nga court mao'y naggunit sa iyang kaso. So, kadtong under trial pa siya. Time for filing a petition. A petition for probation may be filed by the petitioner with the court that tried and sentenced him within the period of 15 days. So, 15 days na siya. Form of petition. Form of petition must be prescribed by the Supreme Court. Effect of filing petition. The court may, upon filing of petition, suspend the execution of the sentence.
The nature and effect of the granting of probation. Probation is merely privilege and such granted rests solely upon the discretion of the court. The grant of probation results in the release of petitioners subject to the terms and conditions by the court and to the supervision of the probation officer. Probation officer may be granted whether the sentence imposes a term of imprisonment or a fine only. An application for probation shall be filed with the trial court with notice to the appellate court if an appeal has been taken from the sentence of conviction. The filing of the application shall be deemed a waiver of the right to appeal, or the automatic withdrawal of the pending appeal. An order granting or denying probation shall not be appealable. Effectivity of the probation order. A probation order is an order imposed by a magistrate or judge which an offender is sentenced to a probation rather than imprisonment, at which time the court shall inform the offender of the consequences thereof and explain that upon his failure to comply with any of the conditions prescribed in the said order or his commission of another offense, he shall serve the penalty imposed for the offense under which he was placed on probation. It shall take effect upon its issuance on the same date. The probation shall commence unless otherwise specified by the court. Who can apply for probation? General rule in probation applies to all sentenced or convicted offenders of all first-timers of crimes punished by imprisonment of not more than 6 years, and any sentenced offender of 18 years of age and above can apply for probation before serving the term of imprisonment. Who are disqualified for probation? Those who are sentenced to serve a maximum term of imprisonment of more than 6 years, those who are convicted of any offense against the security of the state, those who have previously been convicted by the final judgment of an offense punished by the imprisonment of not less than 1 month and 1 day, or a fine of not less than 200 pesos. And those who have been once on probation, and those who are already serving sentence at the time.
Are all counted persons who are not disqualified entered to probation automatically? No. The court will not grant probation if it finds that, number 1, the offender treated better in a mental institution or other place for corrections. Then, number 2, the offender is dangerous risk to the community. Then, number 3, the offense is grievous in the eyes of the community. Terms and conditions in the grant of probation. Mandatory conditions or of probation means required, then or mandatory required. Then a probation order shall require the probationer, which are A. to present himself to the probation office concerned for supervision within 72 hours from receipt of said order. So within 3 days dapat mo report ka na to sa office sa probation. Then B. To report to the probation officer at least once a month during the period of probation. So, mo report ka ngadto sa office, kailangan ka mo report. Then, other conditions of probation, optional or discretionary conditions. The probation order may also require the probationer in appropriate cases, so which are cooperate with the program of supervisions. So mo cooperate ka sa mga programs about supervisions. Then meet his family responsibilities. So you may meet your responsibility of his family. Then devote himself to specific employment and not to change said employment. Then, without prior written approval of the probation officer. Then, undergo medical, psychological, or psychiatric examination and treatment or remain in a specific institution when required for that purpose. Then, comply with a program of the payment of civil liability to victim of his hair when required under the decision of the trial court. Then, pursue prescribed secular study of occasional training. So kailangan ka or ay mo ipurso kung may mga occasional training or whatever. Then, attend or reside in a facility established for recreation or recreations of person under provisions. Then refrain from waiting houses of ill repute. Then lastly is abstain from drinking intoxicating beverage to excess. Then purpose of supervision. The primary purpose of supervision, which are to carry out the conditions set forth in the provisions order. Then, number 2, to ascertain whether the provisioner is following the said conditions. Then 3, to being about the rehabilitations and his reintegrations into the community. So, what happens to a provision if conditions as provisions are violated or violate? So, the probation officer investigate the alleged violations, and if it's established a report submitted to the court, there can be modifications of conditions of provisions by the court depending on the nature and seriousness of the relations. There is possibility of including criminal prosecutions of provisioners in the events of commissions another offense. So meaning pag nag-commit or pag nag-commit ng other offense while you are under provisions, there is possibility you will be re-arrested and re-carcerated.
So, hi guys, I'm here to tackle all about the parole. So, what is parole? A parole term for word, and it used in the sense of, word of honor. Refers to the condition release of an offender from a penal institution after he was served the minimum period of his prison sentence, diba? And word of honor, meaning it is the giving of words of honor or promise to someone, to someone in the sense that inmate promised to conduct him or herself in the law of obeying manners in accordance to the certain rules in exchange for his release. So, through the words of honor of an inmate, kailangan niya tumanon ang mga rules and regulation na gihatag niya kung siya buhian sa prisuhan. So, take note guys that parole is a condition release of offender. So, meaning to say, i-release siya from imprisonment sa iyang pagkapriso but without full restoration of his liberty. Meaning, dili siya totally nga laya, dili siya totally gitagaan og full restoration sa iyang freedom, but instead as a parolee, he is still in the custody of the law, although not in confinement or sa inside sa prisuhan. Di siya totally laya, pero di pud siya gikulong. Diba? Same lang sa provision nga buhian ka, pero you have to comply sa mga condition nga ihatag. So, next is Board of Pardon and Parole. So, sa Minobo is BPP. The BPP. Administrative arm of the President and of his constitutional power to grant executive clemency. Administrators the parole system of the country. It means it was created by virtue of Article number 4103 and it's an agency under the DOJ or Department of Justice. It is tasked to uplift and retain valuable human resources to economic usefulness and to prevent unnecessary and excessive deprivation of personal liberty by way of parole or through the clemency. The BPP or the Board of Pardons and Parole is the one who administer the parole system. Sa atong country, sa atong country, ang board ang bahala to look on the physically, mental, and moral because sa atong prisoner who are eligible for parole or any form of executive clemencies, ang board ang namahala to access or to look for qualifications sa mga piniriso who are eligible. The DPP also assists in the full rehabilitation of the parolees through parole supervision. So, diri na punta sa composition of the Board of Pardon and Parolees. So, first is the chairman, second is the secretary of the DOJ. Members, first is administrator of the PPA or ex-officio member. Second, psychologist. Third, clergyman. Constitution. 4, educator. 5, a person with training and experience in correction work. 6, a member of the Philippine Bar. Note, at least one woman. These are the person who decide to the parolee if he is qualified.
essential elements of parole. Number 1. The prison sentence become final and executory. Number 2. That he served is part of his sentence. Number 3. That he is released after the expiration of his minimum period. Number 4. That said, liberty is the anchor of good behavior. Number 5. That he remains on parole until the expiration of his maximum period. In explanation of that, dapat na judgment of conviction or is final and executory. Ug para makuha sa usa ka preso ang parol, dapat mag-expire ang iyang minimum sentence. Ug exchange of that, dapat magbinuutan siya sa presohan. Ug bisan pa og makagawas na siya, dapat gyapon niya mabuhat ang mga maayong butang kutob sa ma-expire ang iyang maximum period. Kung unsa kadugay ang maximum period, mao pod kadugay siya mag-serve outside the penal institution sa iyang parole supervision under the custody of the law. Parole supervision. The parole must be placed under the supervision of provision. The parole officer is specified in the release documents so that the farmer will be guided and assisted toward rehabilitation. The period parole supervision shall be extended up to the expiration of the maximum sentence, which shall be appear in the release documents. Ang kining parole officer mo kini ang nag-assist o nag-guide sa mga parole na matagaan o ma-assistan sila. Kung nangutana mo kung sa kadugay ang parole mo siya 6 years minimum to 12 years ang maximum period ug una ang 6 years sa kulungan, pero dahil may parole 6 years na kailangan i-serve na lang nila outside the penal institution while under parole supervision until na expired ang maximum sentence mo pa mahuman sa imong parole. Disqualification for parole. Generally, those sentenced with a term of imprisonment of 1 year or less or straight penalty or prison sentence with a maximum of imprisonment. Number 1. Those convicted of offense punished by death penalty, reclusion perpetua, or life imprisonment. Number 2. Those convicted of treason, conspiracy, proposal to commit treason, or expediting. Number 3. Those convicted of administration of treasons, rebellion, sedition, or caught detached. Number 4. Those convicted of piracy or mutiny on a high seas or Philippine water. Number 5. Those convicted of habitual delinquents. Number 6. Those who are escaped from confining or invaded sentence. Number 7. Those who are granted conditional pardon and violation any of the term thereof. Number 8. Those who maximum of imprisonment does not exceed 1 year or those with defined sentence. Number 9. Those suffering from any mental disorder or certified as a government psychiatric and psychologist. Number 10. Those who are conviction is an appeal. And number 11. Those who have pending criminal cases.
Presentation of probation and parole officer. Within the period prescribed in his release document, the parolee shall present himself to the probation and parole officer specified in the release document. If the parolee fails to report within 45 days from the date of his release from confinement, the probation and parole officer shall inform the board of such failure for the board's appropriate action. So, if ang parolee dili makareport within 45 days, diha palamandaan mo take action dayon ang board kung unsay pwede buhaton niya nga nakahigpit kay dili siya basta palayaon nga pasadyunan ra, kailangan gyapon niya musunod ug mag-comply. Transfer of residence. A parolee may not transfer from the place of residence designated in his release document without the prior written approval of the regional director, subject to confirmation of the board. Same lang sa probation, bawal ka nga mobalhin og residence without the approval sa jurisdiction over you, with the approval of regional director, with the confirmation also sa atong board of ug sa atong BPP. Outside travel. A chief probation and parole officer may authorize a parolee to travel outside this area of operation jurisdiction for a period of not more than 30 days. A travel for more than 30 days shall be approved by the regional director. Travel abroad and or work abroad. Any parolee under active supervision has no pending criminal case in any court may apply for overseas work or travel abroad. However, such application for travel abroad shall be approved by the PPA and confirmed by the board. Withdrawal of release document. The board may recommend the withdrawal of the release document if it finds that material information given by the parolee to the board either before or after release was false or incomplete, or that the parolee had willfully or maliciously concealed material from the board. So once nga matagan naka og parol, may release document nga ihatag kanimo, pero posible nga mabawi na, kay the board may willfully recommend the withdrawal of the release document if it finds that na mga material information nga gihatag sa parol nga false or idang gitampered.
Executive clemency. It is the power of the President in criminal cases and its instate convictions to pardon a person convicted of a crime, commute the sentence or reduce it from death to another lesser sentence. So there are many reasons for exercising this power, including real doubts about the guilt of the parties, apparent excessive sentence, humanitarian concerns such as illness or an aged inmate to clear the record of some who has demonstrated rehabilitation or public service, or because the party is a political or personal friend of the president. Next is who grants the executive clemency. The president may grant the reprieves, commutation and pardons and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the occurrence of a majority of all the members of the Congress. Forms of executive clemency: pardon, reprieve, commutation of sentence. Pardon. A pardon is a form of executive clemency that's granted post-conviction. A pardon does lead to the restoration of the right to hold public office or the right of suffrage. Unless explicitly stated in the pardon condition, it however does not absolve the convict for paying civil indemnity imposed by sentence. There are two types of pardons. First, the absolute pardon. The second is the conditional pardon. The Parole and Probation Administration defines an absolute pardon as a total of extinction of criminal liability. It restores the individual his civil and political rights and remits the penalty imposed for a particular offense which has convicted. A conditional pardon will meanwhile refers to the conditional exemption of guilty offender for the punishment imposed of a court. This means there would be certain limits imposed and criminal liability is only partially extinguished according to Article 94 of the Revised Penal Code. A person granted a conditional pardon is required to abide by the limits and guidelines imposed. He or she is also required to be under the supervision of pardon officer. Non-compliance shall result in the revocation of a pardon. Okay, that's all.
Who qualifies for pardon? Convict already served a maximum sentence or granted final release, discharge or court termination of problem may apply for absolute pardon. Explain. Those who want to avail to conditional pardon should already serve at least half of the maximum prison term imposed by the court. 2. How does an application process start? A petition for pardon should be addressed to the Philippine President and Court through the Board of Pardon and Parole (BPP). It should also be supported by documents such as the certificate of penalty of the judge and document service of sentence, among others. 3. Who are the notable recipients of presidential pardon? Philippine presidential usually grant executive clemency, including pardon to convicts who are of old age. 4. Reprieve refers to the deference of the implementation of the sentence for an interval of time. It does not annul the sentence but merely postpones or suspends its execution. The term reprieve was also used generally in reference to the withdrawal of any sentence for a period of time. Explain. The President clemency power also authorizes remission of fines and penalties for federal offense. This type of clemency involves relief from a forfeiture penalty or restitution order, payment of which would result in an hardship. Generally, the applicant must demonstrate a good faith effort to pay their debts and satisfactory post-conviction conduct. A reprieve temporarily postpones the imposition of a criminal sentence, particularly a death sentence, although only a reprieve granted by the President can offer an inmate extra time to appeal for provide the President more time to consider a pardon or commutation. Reprieve is generally an act of clemency that is extended to a prisoner or order to give him or her an opportunity to find a means or reason for reducing the sentence imposed. 4. Commutation of sentence is a reduction in sentence. In a commutation of sentence, a person is not absolved from a conviction completely, but her punishment is substituted with a lesser punishment. Explain. For example, a death sentence may be commuted to a sentence of imprisonment for life. A commutation of sentence may be granted according to those statutes existing in different states. it is permitted by law to granted a commutation of sentence. A governor of a state is vested with the exclusive power to pardon, and it may be subject to legislative control. A legislature may provide for a legislature may be provide for commutation of the sentence of convict for a good behavior, and a commutation of sentence there occur a change in a sentence or punishment. Therefore, it does not include parole because no sentence reduction takes place in parole. The distinction between pardon and commutation are that a pardon is a completely remission of penalty by a sovereign power as authorized by law, but a commutation of a sentence is only a substitution of a lesser punishment for a greater punishment. Also, a pardon has to be accepted by the person who is pardoned, while a sentence may be commuted without the consent of the convict.